registration, whether the state had come to Janssen and told Janssen about what it had learned here, right? You remember that question?
I don't remember it exactly that way, so you just said something that I hadn't picked up before. Did you say it was an undercover investigation? Meaning, could they have told you when you asked me that question if it was an undercover investigation?
My question's a little different, Ms. White. My question is,
Okay.
do you recall where we left off last week, and yesterday, I'm sorry. And the last question I'd asked you was whether at any time between 2007 and 2015, the state had informed Janssen of what it had learned in 2007 about Dr. Myers.
I don't know if they informed you or not, but I don't know at what point they could have if it was an undercover investigation.
So, and as I recall, the answer to my question yesterday was, no, you were unaware of any instance where the state had informed Janssen during this time period about what it learned about Dr. Myers in 2007. Am I recalling your testimony correctly?
That's what I said yesterday, correct, but what you just said, I think I said in my first answer, you said something today I'd not clued in on before when you called it an undercover investigation in your first question. I don't know at what point they would have even been allowed to tell you, but I'm not aware of the state telling you.
And if there's no objection, Mr. Whitten would like to publish the updated version of this that I just handed you. Is that all right?
No problem.
All right, so if we can put this one up, Ms. Conway. Now, Ms. White, what we've done here is we've added to this timeline number of sales visits that Janssen representatives made to Dr. Myers during this time period. And we've counted them up. We've counted 10 in 2009, 22 in 2010, and 18 in 2011. You see that?
Yeah, I see that.
And so I take it, however, that you're not aware that at any point along this period, the state provided Janssen any of the information it had about Dr. Myers, right?
So you're asking me if during their undercover investigation, when Janssen's own sales reps were calling on this doctor, whether or not the state during its undercover investigation told Janssen's sales reps who were there presumably pushing Janssen products about this doctor. In addition, if I remember the testimony correctly from the beginning, Janssen purchases from retail pharmacies and other entities the prescribing information. So you would have had the prescribing information. Your sales reps are in there pushing your product, and you want to know if I'm aware if the state of Oklahoma told you or your sales reps about an undercover investigation that they were doing.
Do you know the answer to the question?
I do not know.
All right, so you're not aware of a single time when the state came to Janssen, provided any warning whatsoever, are you?
I do not know if while your sales reps were there pushing this product, if they were told about an undercover investigation the state was doing.
And I take it you also don't know whether Dr. Myers wrote a single prescription for Nucynta, a product that came out in immediate release form in 2009, extended release form in 2011. I take it you also don't know whether Dr. Myers wrote a single Nucynta prescription during that time period, do you?
I believe, if I remember from what you were showing me yesterday, Dr. Myers was writing opioid prescriptions. It may have been for the products for which you provided the majority of the API, but I don't know whether he actually wrote a Nucynta product.
All right, so sitting here today, I guess I take it then, the answer to my question is you can't tell us whether he wrote a single prescription for Nucynta at any point during that time period, fair?
I do not know the answer to that.
All right, so let's go back, and I want to talk about another individual who we saw yesterday, and that is Dr. Swain. And Your Honor, if I may approach.
You may.
Thank you.
Now, you recall yesterday we saw Dr. Swain second a motion to exempt OxyContin from quantity limits in the DUR board meeting minutes that we looked at. You recall that? Sorry. In the DUR board meeting minutes that we looked at yesterday.
You're asking, sorry, say that again. I don't remember what you're saying. I'm not doubting it, but I don't remember what you're
Just
saying.
asking if you recall yesterday when we saw Dr. Swain seconding a motion to exempt OxyContin from quantity limits in the DUR board minutes that we looked at yesterday. We don't need to go back. I'm just
Yeah,
asking.
I remember Dr. Swain's name, and I remember you telling me to remember it. I believe you if that's what he did, but I don't remember that that was it.
Okay, I've handed you a document that we've marked as J288. This is an email produced by the state from Cindy Hamilton. And you know her today as Cindy Hamilton Fain, correct?
I did not know that was the same person, but I do know who Cindy Fain is.
Okay, thank you. And Your Honor, we would offer J288.
Objection.
J288 will be admitted into the evidence, and you may publish.
Thank you. And what we see here, this is an email that Ms. Fain is sending to a listserv, RX News, NADDI RX News. And she starts off saying she's tried to refrain from submitting to the listserver, but she says everybody has an opinion, but very few facts. She says there was no doctor, referring to prescriptions. They were all forgeries for 7 years. If the pharmacist had bothered to pick up the phone, he would have found that out. For 6 to 7 years, this woman forged prescriptions and spent over $3,000 cash a week in one pharmacy. She was receiving an average of 63 hydromorphone 4 milligrams per day, 52 Percocet per day, 27 OxyContin 40 milligrams per day, 15 meperidine per day, and 6 Valium 10 milligrams per day. And then it goes on. Ms. Fain goes on. She didn't go to multiple pharmacies. She didn't need to. Nobody questioned her at the one pharmacy. Then she dies, but the doctor of pharmacy doesn't know it. And someone comes in and says that she needs her meds. So the doctor advances her 120 of each, including the Schedule II drugs, on the word of a friend of the patient, not even attempting to call the physician. And then she concludes only a week later, when he doesn't receive the original C2 in the mail, does he bother to call the physician and find out that there is no such patient. This pharmacist had a duty to call the physician a long time prior to this and ask about the doses. I'm an advocate for pain management, but I'm also an advocate for communication to the physician. And then she asks, second-degree murder seems harsh, but he was definitely culpable. And this is dated, what's the date on this, Ms. White?
April 25th, 2005.
All right. Now, let's move forward, and if I may approach again, Your Honor.
You may.
And Reggie, this is part of the 2942, so I'm proposing to mark it as 2942A for now. That's all right. And Your Honor, we're going to mark this as 2942A for now.
May I have a moment, Your Honor?
Yes.
It's not quite quiet, sorry.
It's still squeaking.
Yeah, well, it doesn't bother me. I just don't want it to bother her. Thank you.
Hiking session made it squeak.
Again, Your Honor, as we discussed yesterday.
Chair.
It seems to us, under the rule of completeness, the whole thing should be offered. Don't have a problem with the display less than the whole thing. But it looks like, and I'm just now seeing this, but it looks like they're cherry picking and just marking part of the exhibit. So we would object to that and rule of completeness.
And Your Honor, we can take this up at the break. I'm going to focus on this portion now, and I don't think we would have an objection to admitting all of 2942, but
Does
given
the state have an objection to admitting all of 2942? So I'm going to admit all of 2942 as one exhibit. Right now, I'm admitting as this particular exhibit, 2942A.
Okay, yes.
That sounds reasonable.
Okay.
Thank you, Your Honor.
So yeah, at the break, we'll need to have one complete.
Yeah.
It's a huge document, right?
It is, yes. And we can address it at the break.
Yeah,
It's
we'll
the
figure that out.
It's the Board of Pharmacy minutes, so.
And this is, to be exact, this is J, not a state exhibit.
Correct.
Okay, thanks.
So, and may we publish, Your Honor?
You may.
Thank you. So, Ms. White, if you turn to the second page of the document, in the middle, there is a case reference, case 712. You there?
Yes.
And this is OSPB, Oklahoma State Board of Pharmacy versus James Milton Swain, PhD, and Buy for Less Pharmacy of Penn, right?
Yes, it looks like it.
And if we read the case description in the minutes, we see the board was called to order by President Spoon to hear case number 712. Mr. Swain was present with counsel Linda Scoggins. Assistant Attorney General Grant Moak prosecuted for the board. Mr. Swain was charged with failing to address the possible addiction or dependency of patients with CDS drugs. Medications involved were diazepam, meperidine, OxyContin, Endocet, and hydromorphone. There was an excessive quantity of these prescriptions filled over a 4-year period, which were finally found to be forgeries. Once it was discovered that the physician had not written the prescription, Mr. Swain failed to notify the board or any other law enforcement agency, right?
That's what it says?
And as a resolution, we see the indication that Mr. Swain entered into an agreed order that was accepted by the board. His license was suspended for a period of 5 years until October 26, 2009. And it was indicated that the suspension would be stayed, and then license would be on probation for the remaining period in which the suspension was stayed. And then he paid a fine, and he was going to attend a one-day seminar in the next 2 years, in addition to his continuing education requirements, right?
I think that's what it says.
All right. And if I may approach, Your Honor?
You may.
Thank you.
And I've handed you a copy of what we've marked as J878. And these are Board of Pharmacy, the Board of Pharmacy packet dated December 8th, 2004 for the December 14, 2004 meeting. You have that?
Yes.
And Your Honor, will offer J878 and request permission to publish.
Objection.
J878 will be admitted into the evidence and you may publish.
And if you would flip to page 5, Ms. White.
Yeah, I am looking. This is the December meeting, and it looks like also on page 5 that Johnson & Johnson lobbyist Richard Ponder was there again.
As somebody present at the meeting, correct?
Absolutely.
And what we see here under the list of board members, we see James M. Swain, Doctor of Pharmacy, correct?
I do see that.
And that is the same name we see in what we marked as 2942A in the OSPB versus James Milton Swain case, correct?
I believe so.
And he was present at meetings of the Board of Pharmacy during the time that his license was suspended, correct?
His license was, I don't remember what year his license was suspended, but I'm assuming if you showed me the last one, it would say that, since you're asking me that. But I didn't remember the year.
Do you know how long he was permitted to remain on the board after his license was suspended and after this conduct was discovered?
I do not.
Is that not something you looked at in preparation for your testimony on causes of the opioid crisis?
I think I told you multiple times yesterday, I've not looked at the DUR board minutes.
All right, so let's fast forward a little bit back to the time period where we left off yesterday, which is February of 2008. And if I may approach again, Your Honor.
Yes, you can.
Thank you.
Ms. White, I've handed you a copy of what's been marked as Exhibit J 1035. You have that in front of you?
Yes.
And that is the DURB meeting packet for the February 13th, 2008 meeting, correct?
It looks like it.
All right, and we see, if you want to look at the packet contents, they appear on page 2. You there?
Yes.
And the Appendix C item listed is 60-day notice to prior authorized narcotic analgesics, right?
I see that.
All right, now if you could turn to page 20, which is the start of Appendix C, and Your Honor, we would offer J 1035 and request permission to publish.
No objection.
Sure.
J 1035 will be admitted into the evidence and you may publish.
Thank you. Ms. Conway, if we could go to page 20.
What page?
20.
I'd also note as I'm turning on page 6, Johnson & Johnson's lobbyist was again present.
Yeah, and I believe Ms. White, the court heard testimony from Mr. Ponder regarding his attendance at DUR board meetings. And I don't know if you were here that day or not.
I was not here the day that the video was played from Mr. Ponder.
All right, thank you. So are you on page 20?
I am.
And this is Appendix C, 60-day notice to prior authorized narcotic analgesics. You there?
I am.
And this is from the Oklahoma Healthcare Authority dated February 2008, right?
I'm looking for the February 2000. I mean, it's for their meeting.
It's right at the top of the page. It says Oklahoma Healthcare Authority, February 2008.
Oh, yes. Thank you. Sorry.
Now, the first thing that is listed here is total reimbursement. You see that?
Yes.
And there's a list for various different products, correct?
Yes.
And you'll see, for example, OxyContin is listed there.
I see that.
And we see 8,837 claims and 560,773 units for 258,064 days worth of medication, right?
It looks that way.
And we also see Duragesic on there. You see that?
Yes.
And we see the number of claims, 57, right?
Yes.
Is that too many?
Is 57 too many? Is 8,837 too many?
Is 57 too many?
I can't speak to the certainty of the individual medical case, but do I think by this point we had an oversupply of opioids, including the ones Janssen manufactures like Duragesic and the one they provided the API for like OxyContin? Yes. Can I speak to those specific 57 claims? No.
So 57 is, I mean, do you have an opinion on whether 57 is too many?
I think we had an oversupply of the products Janssen manufactures, including Duragesic in 2008, and OxyContin and other products for which Johnson & Johnson and Janssen provided over 50% of the active ingredient in 2008. But if you're asking me if these 57 claims are too many, I can't answer that. I don't know the specific claims, but it's pretty likely by 2008 that this was an oversupply.
So I'm trying to understand your testimony. So your testimony is that there was an oversupply of Duragesic in Oklahoma in 2008. You just don't know which patients shouldn't have gotten their prescriptions. Is that it?
There was an oversupply of opioids, including Duragesic, in 2008. But for these are specific claims. These aren't. You're not just saying 57. You're saying these 57 claims. I don't have the detail behind them and can't speak to those, but it's likely an oversupply is what I think I've said it pretty clearly.
How many is too many, Ms. White?
How many, what is too many? I'm sorry.
Let's start with Duragesic. How many Duragesic prescriptions is too many?
I think when you look at the data and you look what was happening pre-96 in terms of availability of all opioid products versus what was happening in 2008, it can give you a pretty good ballpark of what oversupply looks like, and returning to pre-96 levels would not be an oversupply. Now, for Duragesic specifically, I can't give you a specific number. I can tell you we have an oversupply of all opioids, which is the problem. All opioids were pushed. All opioids were pushed through unbranded marketing, and that is the problem. Now, this exact 57, I can't give you an answer to. I don't know how else to say it. I cannot tell you for those specific 57 claims.
So let's take all opioids. How many is too many? Why don't we take OxyContin? Is 8,837 claims too many?
I can't speak to these specific 8,837 claims because I don't have the detail, but I can tell you 8,837 OxyContin claims seems like a high number. I believe this is indicative in 2008 of showing that we had an oversupply of opioids, including OxyContin, for which I believe you all were looking at the previous chart, over a 60% supplier of the API of that product.
We've talked about the API a little bit yesterday. My question...
Pardon me, Your Honor. She was in the middle of a sentence.
I think she was done, but I'm welcome to ask her.
I was talking.
Let's let her finish this answer.
For which you were the supplier of over 65% of the API in the product, and this is an oversupply. The exact number, I can't tell you if the exact number today, but I can tell you going back to pre-96 levels would not be an oversupply, and the levels we had in 2008 were an oversupply.
So you are telling the court that every single opioid prescription written in the state of Oklahoma that exceeded the number of prescriptions written in 1996 was an oversupply of these FDA-approved prescription-only medications?
I am saying very clearly to the court that the giant number of opioid prescriptions we had in 2008 was an oversupply, that the pre-1996 levels, and for the decades before that where we had a low number of opioid scripts, does not appear at all to have been an oversupply, and that the 2008 gigantic numbers of opioid prescriptions sold is absolutely an oversupply.
So is it your testimony, Ms. White, that every single prescription that pushes for opioids, all opioids combined, different indications, long-acting, short-acting, you put them all together, and every single one, over the number that were prescribed in 1996 in Oklahoma is, in your opinion, an oversupply of opioids?
I don't believe that's what I said.
So there's some number that's the right number, but you don't know what the right number is.
I don't believe that's what I said either. Neither of those two characterizations you just made are what I said at all.
So why don't we go back to the 8,837 OxyContin prescriptions that we see here? And you indicated that that seems like a high number to you. But if I understood you, you're not saying that any one of those 8,837 prescriptions constituted an oversupply of OxyContin, are you?
Pardon me, Your Honor. She has answered this multiple times, both on the 8,000 and the 57. Multiple times, she has answered this clearly.
Your Honor, I don't think we've got...
I'll overrule the objection.
Thank you.
I'm sorry, can you say that again?
Sure. So if I understood you correctly, referencing the 8,837 OxyContin prescriptions, your opinion is that that is likely an oversupply. I'll start with that.
So what I'm saying is the 8,837 prescriptions are an oversupply. I cannot tell you which ones specifically are the oversupply, but this is certainly a number that far exceeds pre-96 levels if you were to calculate this out for the full year, not just 1 month. And yes, this is very clearly and indicative of the oversupply.
Now, first of all, this is 6 months. It's January through June 2007, correct?
Yes, sorry.
And you said that the 8,837 prescriptions are an oversupply. So let me ask you this, what's the right number? What number do we have to get down to over this 6-month period before we can say there is not an oversupply?
Objection, asked and answered. She's indicated several times she can't tell individually.
Your Honor, she said she can't speak to individual prescriptions. She didn't say that there wasn't a number, and I'm entitled to probe her on whether there is a number.
How can she give a number when she says she can't go to the individual prescription? She's answered this much.
The witness has answered the question. I
So,
sustain the objection.
Taking the issue more broadly, focusing not on the 57 Duragesic prescriptions, but let's say all Duragesic prescriptions prescribed by doctors in the state of Oklahoma in the year 2007. Let's take the entire year. How many is too many?
I don't have an exact number memorized of what we had pre-96 to today. What I do, am trying to say very clearly, and I'm sorry if I'm not saying this very clearly, we have too many opioid prescriptions, including Duragesic, including other forms of fentanyl patches, including opioids, including OxyContin, including hydrocodone, including morphine, including codeine, for which you all provided over 50% of the API. They're all too high by 2008. Can I tell you the exact number that it should be pre-96? I did not memorize those, and I'm sorry, I don't know that here today. But I'm trying to tell you very clearly what it is I'm saying.
So, to sum it all up, it's too many. Might not be these 57, this might be an okay number. Too many opioid prescriptions out there, but you can't say how many in 2007 was too many. Fair?
No, I don't think that summary is fair.
Well, if that's not fair, how many was too many?
I feel like I've said this multiple times. I can't tell you the exact number. The part of your summary that I disagree with, that when you say fair, is that these 57 may have been oversupply, may have not been. I'm saying clearly we had an oversupply of Duragesic, of OxyContin on this particular chart, in addition to a host of other opioids. Can I tell you which of these individuals, these claims for certain individuals, fall into the oversupply category and which don't know? But I think the numbers clearly demonstrate it, and they should be at pre-96 numbers, which I don't have memorized, and I don't know how else to communicate that to you, but your summary was not a fair characterization.
So would I be understanding you correctly to say you're second guessing the prescribing of a certain number of unidentified Oklahoma doctors for a certain number of unidentified Oklahoma patients who you do not believe should have gotten their medications in 2007?
No, I don't believe that would be correct. I'm not sure if I'm not communicating clearly or if you're not understanding what I'm saying, but your summaries of what I'm saying are not correct.
So let me ask you this question. Who should have been, well, let's just take the 57 claims for Duragesic, okay?
Mhm.
Those were prescriptions written by Oklahoma doctors for Oklahoma patients who were part of the Sooner Care program, correct?
I can't say for sure if there were Oklahoma doctors and they were definitely Oklahoma patients, but if someone was out of town, no, I haven't seen these claims, so no. Part of what, you're saying things in your question, and I don't know if you mean to or not, but you're saying things in your questions to me, asking me to confirm that I think aren't correct statements. So I don't know how to say yes when you say, is that correct?
Well, you make a fair point. These are 57 claims that were submitted to Sooner Care on behalf of Sooner Care beneficiaries for reimbursement of Duragesic prescriptions, correct?
Yes, I think that's correct.
And you understand that a prescription for Duragesic has to be written by a licensed prescriber, correct?
Correct.
Patient can't go to the pharmacy and just buy a prescription for Duragesic without having that prescription written by a licensed health care provider, right?
That's correct.
All right, and your point is somebody could have gone to a doctor out of state, come back, filled their prescription, and had the claim go to Sooner Care because they're a Sooner Care beneficiary.
I believe that's true. If they had been out of town and something could have happened.
All right, let's turn to the recommendations that are provided in this section. And I believe you have to go to page 22. You there?
Yes, I believe so.
And what we see here is a recommendation made by the College of Pharmacy that long-acting narcotic analgesics be added to the product-based prior authorization program, correct?
That's what it says.
And then there's a chart that lays out 3 tiers, right?
Yes, it appears to.
And there are recommended criteria. Those are the prior authorization criteria for the 3 tiers there, correct?
I think that's the recommended criteria. You said those are the prior authorization criteria. I don't know if that was the prior authorization criteria at this time, but I think they're recommending it.
That was my question. It's the recommended prior authorization criteria.
But that's not what you had
Given the
said.
3 tiers, correct?
I believe so.
And you see there that at that point in time, there was going to be a recommendation that Duragesic go in tier 1, but there's a little symbol there, isn't there?
Yes.
And we see the indication that Duragesic would move to tier 2 or tier 3 if the current manufacturer's federal rebate status changes, right?
Yes.
And basically, shorthanding it, they were saying that if something happens that makes Duragesic more expensive, it'll be moved to another tier.
I don't think that's the complete picture. I think there's a requirement that for Medicaid programs, that if there is an FDA-approved product that is part of a rebate program, Medicaid programs are required to cover that product. So this may be referring to the federal requirements over which the state Medicaid agency has no authority, that if something is an FDA-approved product on a rebate, they have to cover it. I don't know that this non-binding body can do anything about that.
So you understand that products in tier 2 and tier 3 are still covered by Medicaid, don't you?
I believe so.
And no matter what tier a product goes in, tier 1, tier 2, tier 3, the product is eligible for reimbursement subject to prior authorization requirements by Sooner Care, right?
I believe that is true.
All right, and if you turn to the next page, page 23, you'll see that the Oklahoma Healthcare Authority, in this document they prepared, recognized the potential program savings from the tier system, correct?
Sorry, hold on a second. Microphone wire is caught on my shoe. No, that's not your fault. Okay, I'm so sorry. Go ahead.
You'll see on page 23 that the Oklahoma Healthcare Authority recognized potential program savings by structuring prior authorization to the 3 tiers, correct?
That's what it says here.
And that would be realized by a potential shift of market share from tier 3 and tier 2 to tier 1 if rebates would be available for the tier 1 drugs, right?
That appears to be what it says.
All right, let's move forward to April of 2008, if I may approach, Your Honor.
Yes, you may.
Thank you.
And this, what I've handed you, Ms. White, is the packet for the April 9th, 2008 DUR board meeting, right?
Yes.
Your Honor, we offer 3914 and request permission to publish.
J3914 will be omitted and may publish.
And if you would turn to page 2, Ms. White, where we see the various contents.
I see that.
And if you look at Appendix D, you'll see action item, vote to prior authorize narcotic analgesics, correct?
I see that.
And if you would, turn to page 21. I want to look at that appendix.
You're going to have to give me the name because the page numbers are cut off my copy again.
Why don't you go to 20 is not cut off?
No, all my page numbers are cut off.
Okay, if you look on the other side, I think that
You can see
it looks
25
like
and
the
27.
even number of pages do show through. If not, you can have my copy, that's fine. I'll trade.
I think I'm there. Is this it?
That's it, yes. And this is the vote to authorize narcotic analgesics, and it's listed, we see the Oklahoma Healthcare Authority, April of 2008, correct?
Yes, I see that.
And in the middle of the page, it says recommendations, right?
Yes.
And we see there that Duragesic has been moved to tier 2, correct?
It appears to be.
Right, and in tier 1, we have all immediate release narcotics not listed in a higher tier, right?
That's what it says.
And then there's a note, another note next to Duragesic patches that says product would move to tier 3 if current manufacturer's federal rebate status changes, right?
I see that.
Now for tier 2, which was the recommended status, we can look down below this chart and see the recommended criteria. And the first criteria relates to tier 2 agents, and it indicates that they will only be approved after a minimum 30-day documented trial titration period of at least 2 tier 1 agents in the past 90 days, or clinically appropriate pain therapy requiring time-released medication. In either case, diagnosis should be for pain related to a chronic condition, right?
This is it. I think that's what it's saying. So it's saying that these products should be used for chronic pain by this point? Is that what it's saying?
It's giving 2 criteria, correct, for approval of tier 2 agents as part of the prior authorization requirements, correct?
It appears to be.
All right, if I may approach, Your Honor, we're going to move forward to next.
Yes.
We're making progress. White, I've handed you a copy of what we've marked as J456. You recognize this as a copy of the board packet for May 14, 2008 for the Drug Utilization Review Board.
Yes.
Your Honor, we offer J456 and request permission to publish.
No objection.
J456 will be admitted into the evidence. Permission granted.
And if you would turn to the 15th page of the document, Ms. White. And this is part of a memorandum from Shelley Gorman-Keast, Drug Utilization Review Manager, to Nancy Nesser, the Pharmacy Director for the Healthcare Authority. You see that on the prior page?
Oh, sorry, I was looking on page 15. You want me to look at page 14?
Yeah, page 14 just as a reference.
Sorry, I really was looking at page 15 when you asked. Did you ask me if on page 14 it says it's from Shelley Gorman-Keast to Nancy Nesser? Is that your question?
Correct.
Yes.
All right. And that memorandum continues on to page 15, and we see recommendation number 2. It's up on the screen as well. Vote to prior authorize narcotic analgesics, right?
I see that.
And if you see up at the top, it says motion carried by unanimous approval, right?
It says that?
And the motion that carried was to recommend adding, based on the tier system that we see here, which put duragesic patches into tier 2 and left all immediate release narcotics that were not listed in a higher tier in tier 1, correct?
It seems to say that.
All right, now let's shift gears a little bit as we move forward in time, and I want to talk a little bit more about the PMP. And if I may approach, Your Honor.
Yes, you may.
Thank you.
And I've handed you a copy of a September 2008 email, originally from Mark Woodward. We talked about him yesterday, I believe, right?
I don't remember if we talked about Mark yesterday. but
You know who Mark is.
I know Mark, yes.
He's at the Oklahoma Bureau of Narcotics, right?
Correct.
And I believe he is the communications and legislative director. Is that right?
I don't know if that's his exact title, but I know he has those duties.
Those are his functions.
Yes.
All right. And this is to Charlie Price. Actually, if we go down, the original email is from Mark Woodward to Charlie Price in the Attorney General's office, correct?
It appears to be. It's
And-
broken up on my copy, but it appears to be.
All right. And he writes to Charlie Price, and the email address is at oag.ok.gov, right?
Yes.
Attached are some prescription drug abuse reports. that
Actually,
might-
it's at oag.state.ok.us is what it says.
I'm looking at the top one, where we see the reply from Mr. Price.
Oh, I'm sorry, I was looking at the one down here. I thought you wanted me looking at the original email.
Yeah. So, in any event, Mr. Woodward, if we may publish, Your Honor. Actually, let me offer this. I'm going to offer J637.
J637 admitted into the evidence,
And
you
may
may
we
publish.
publish?
Yes, you may.
He writes, if we can bring that out, Ms. Conway. Attached are some prescription drug abuse reports that might be useful. In the attached version report are some very alarming stats from our prescription monitoring program showing the number of Oklahomans going to 5, 10, or more doctors. Some seeing as many as 66 docs to get meds for an addiction. It shows we dispense nearly 104 million doses of hydrocodone per month. That's about 30 pills for every man, woman, and child in Oklahoma each month. Call me if you have any questions about it, right?
Yes, this is exactly what I was talking about when you oversupply opioids and you turn on that addiction circuitry, people are addicted and take more and more medication. This is talking about people who have an addiction.
Right, and at this time, I believe this is 7 years before Oklahoma required that doctors check the PMP when writing a prescription for an opioid medication, correct?
I think that's correct.
And are you aware of any steps that Oklahoma took to institute that requirement at the time that Mr. Woodward brought this report to the attention of Mr. Price in the Attorney General's office?
I know steps that were taken, as you've heard testimony before today, that I know that there were several steps taken around the PMP system. We were one of the first states to have it. We were one of the first states to have it real time. We were one of the first states to give doctors access to the PMP before other states even had a PMP. We were one of the first states to send reports from the PMP to doctors. And we were attempting to get the PMP to be mandatory prior to when it became mandatory, but there were lots of steps. And I think OBN testified or was deposed and talked a lot more about what those steps were. But those are some of the steps that I'm aware of when you asked me if I'm aware of any steps.
My question was a little more specific. I asked you if you were aware of any steps that the state took to make the PMP, checking the PMP mandatory for doctors at the time that Mr. Woodward forwarded this report and these very alarming statistics to Mr. Price.
I don't know if there was a specific action at that time working on mandatory PMP. I know there were steps trying to work on mandatory PMP prior to when it became mandatory, but I don't know if they were happening at this in September of 2008.
Okay, that's not an issue that you looked into in preparing to come to court and offer your causation opinions?
I have never seen this email until today, so I did not look to see when the day this email was sent, what was happening. No, I did not.
All right. Within the document is the diversion report for 2006 and 2007. It starts on page 7, and I'd like to focus on page 9, which is the third page of the report, 9th page of the document.
Okay, give me just a second. I haven't seen this before, or I don't recall seeing this before.
And I want to focus on the full paragraph. It's the second paragraph there. And just the estimates that OBN provided in this report. We look in the middle of the page, OBN indicated that it was estimated that approximately 87,000 Oklahomans who routinely obtain controlled drugs from the medical community sell these drugs or use them for other than medicinal reasons, right? That's what he indicated, correct?
I'm so sorry, hold on. I had asked you just a second ago, just let me look at this really quickly because I had not seen this before. I'm going really fast though, hold on. I see that.
And if you turn to the next page, there's a
So,
list
I'm sorry, let
of,
me make sure I understand what this sentence is saying that you're having me read. It's saying that it's estimated that approximately 87,000 Oklahomans who routinely obtain CDS, opioids, from the medical community sell those drugs or use them for other than medicinal reasons? Is that what it says?
you read it as well as I could.
It's interesting to me because when you gave me the report and I'm looking on the first page, the first paragraph talks about when you break down the numbers quoted by the U.S. drug czar, John Walters, there's an estimated 87,000 Oklahomans addicted to prescription drugs. And so when I look at that and see this 87,000, it's talking about the drug czar on the first page saying 87,000 are addicted. So I'm trying to figure out if there's some confusion here when it's saying they're selling them, if they're actually referring to the 87,000 Oklahomans that are struggling with addiction that the drug czar is referring to on page 1.
Well, if OBN was confused about the statistics, I'm sure Mr. Whitten can ask you about that on redirect. I'd like to go to the next page for now and focus on what is listed at the bottom of page 4 as the prescribed narcotics in prescription.
The bottom of page 4?
Bottom of page 4.
It's also 10.
Also 10? Thank you. Sorry.
Page 4 in the annual report, page 10 in the document. You there?
I believe so.
And then what they list are the prescribed narcotics in prescriptions and doses, and they are focused on tablets and capsules, correct?
It says that?
They're not focused on patches, correct?
I don't see it saying patches here.
And fentanyl is not listed as one of the drugs there, is it?
Fentanyl is not listed here.
All right. If I may approach, Your Honor.
Yes.
I'll tell you what, we'll come back to this one, okay? Let's go to 1114.
Thank you.
So, Ms. White, we are moving into 2009 and looking at the Drug Utilization Review Board packet for the February 11th, 2009 meeting marked as Exhibit J 1114, correct?
Correct.
And we would offer J 1114 and ask permission to publish, Your Honor?
No objection.
J 1114 will be admitted into the evidence, and you may publish.
Thank you. And if we look at page 1114, or I'm sorry, Exhibit 1114, I want to go to page 41. You there?
Yes.
And what this is if we look at the bottom of the page in this report for the DURB, there was a comparison of other medications with abuse potential that was done, right?
That's what it says?
And we see that in August of 2006, an edit was put in place to allow only 90 days of carisoprodol products every 365 days. This has caused an approximate 50% decrease in the cost of carisoprodol and a 60% decrease in utilization, right?
That's what it says?
And then there's an indication that there's a cyclical increase in claims every August as the 90 days reset, correct?
It says that?
And if you would, please turn to page 42. And what we see reported is that a similar edit, in the middle of the page here, and first of all, let me approach, Your Honor.
You may.
We see what's being charted here are both claims and costs of carisoprodol before and after that August 2006 edit that was put in place, correct?
It appears to.
And it shows a fairly significant impact on overall utilization, correct?
It shows a drop in utilization.
And then what we see is they go on to report that a similar edit could be placed on hydrocodone. And there's some analysis. The following tables indicate the number of members that would be affected by various limit cutoffs. A 3-claim limit would result in 18,164 members requiring prior authorization, and a 90-day supply cutoff would result in 10,114 members requiring prior authorization, correct?
I believe that it says that. When I was
And-
flipping through it, it looked like this is a meeting again where J&J's lobbyist was present.
And one of the things, and you know, as we said, I know you missed Mr. Ponder's testimony on that subject, but one of the things that this shows is the recognition that requiring edits and taking steps to require prior authorization, to impose quantity limits, what that does is it impacts utilization. And as we saw in some of the minutes yesterday with some of the statements from the Drug Utilization Review Board members who are physicians, it impacts prescribing, right?
I believe we saw a statement that said that yesterday.
And there are, Rich, are you sure?
Yeah, sure.
And as we see on the chart that you referenced numerous times during your testimony yesterday, apologies, there aren't enough permission to walk.
You're fine.
There are numerous different things that can impact the ultimate decision of a healthcare provider to prescribe a medication, correct?
What this chart is showing is,
I'm sorry, Ms. White. My question was, very simple question, I'm sorry. There are numerous things that can impact a prescriber's decision to prescribe a drug, right?
so you didn't,
Pardon me. I think she should be allowed to answer. He asked, and they didn't want her to answer.
Your Honor,
I think in this case, Mr. Brody's asking for a yes or no question.
so you're saying, let me understand the yes or no you're asking me. You're saying based on this chart that you just got out to ask me this question, if this chart is showing there's multiple things that influence,
let me ask
What?
you the question this way. You understand there are numerous things that can impact a healthcare provider's decision to prescribe a drug for a patient, correct?
and you're no longer trying to say it's based on this chart that's the influence map of J&J, correct?
I'm just asking.
I want to make sure I understand what you're asking
I'm
me.
asking you a question without reference to the chart itself.
Okay, so if it's not the chart, which is J&J's influence map, if you're just asking me in general, do multiple things affect prescribing and healthcare decisions? Yes.
And among the things that can impact prescribing decisions that we see here are state medical and pharmacy boards, right?
Well, no, as what you see here, this is the people J&J was trying to influence. When you start using that chart and then trying to tell me it means something else, that's when I'm saying I can't answer it that way.
I appreciate, Ms. White, your interpretation of the evidence that you have seen during those portions of the trial that you've been here for. But my question is, as we see from the chart here, decisions that are made by state medical pharmacy boards can have an impact on prescribing, correct?
Decisions that are made by state pharmacy boards?
Correct? State medical and pharmacy board decision-making, just as decisions by other payers, like health plans, insurers, health plan administrators, similar to the impact we see here on utilization from the carisoprodol edit, can impact how medicines are used by prescribers, correct?
Your question is very confusing to me. If what, and I really am trying to help you on this, if what you're asking me is, this is not the state pharmacy board. This is the DUR board, the chart you're pointing to over here to me. This is a DUR board, which is an advisory body with no authority. If you're saying decisions they make, this isn't a pharmacy board decision chart. This was a healthcare authority decision chart. If you're saying decisions that the DUR board makes can affect prescribing, that is not correct. The DUR board doesn't have that authority. If you're asking me, can the healthcare authority make a decision that affects prescribing in the Medicaid program, the answer would be yes. And so I'm confused on what you're asking me.
Are you aware of a single recommendation related to narcotic analgesics ever made by the Drug Utilization Review Board that was rejected by the healthcare authority?
Related to narcotic analgesics only? I don't know.
So, expanding beyond the healthcare authority, the Medicaid program has a payer, right?
Correct.
And decisions made by payers, you would agree, and as we see here, can have an impact on prescribing activity, right?
You showed me a statement made by a physician yesterday that said decisions made by a payer can affect prescribing.
And we see here the data presented by the healthcare authority. This is the document from the healthcare authority showing that the restriction that was put in place in August of 2009 had a significant impact on utilization.
It appears to have impacted utilization.
You want to turn around?
Thank you. No, I don't care. Put it back.
I like it that way.
All right. We can put it this way too.
Thank you.
All right, let's move further in to 2009, if I can approach, Your Honor.
You may.
Thank you.
And Ms. White, I've handed you a copy of what's been marked as Exhibit 1160. This is the packet for the August 12, 2009 Drug Utilization Review Board meeting, right?
Correct.
And Your Honor, we offer J1160 into evidence and request permission to publish.
No objection.
J1160 will be admitted into the evidence. You may publish.
And this is, if we look back and recall what we looked at yesterday, this document is nearly a decade, not quite, but nearly a decade after we first saw the board recognize abuse and diversion issues, as well as issues related to hydrocodone, correct?
You're saying the first packet you showed me was something and that was a decade before this?
Almost a decade. I think we started on the recognition of the abuse and diversion issues yesterday in 2001, if I'm recalling correctly.
I don't remember, but I will believe you that you know which packet you gave me.
And we can agree that 8 years is almost a decade.
Correct.
All right. If we look at the, excuse me, the items included in here, they're on page 2. And we see action item D is vote to apply quantity restrictions to hydrocodone products, right?
I see that.
And if you flip forward to page 26, this is part of Appendix D, and we see that title, vote to apply quantity restrictions to hydrocodone combination products. You there?
Yes.
And we see that there are 3 recommendations: retain ingredient duplication module, to establish a new quantity limit for a maximum of 6 tablets per day, or 3,250 milligrams of APAP, acetaminophen per day, whichever is less, on the combination products, and establish an annual claim limit of 12 per 365 days, right?
APAP is acetaminophen, is that what that means? I don't know what APA means.
For
Sorry.
the combination products, correct.
Then yes, I believe that's what it said.
All right, and so those are the recommendations that were presented by the Healthcare Authority in August of 2009, right?
That's what it says?
All right, let's move forward, and we'll take a look at how things progress. If I may approach, Your Honor?
Yes, you may.
Thank you.
So, Ms. White, I've handed you an email. The top email is to Nancy Nesser. It's a document that was produced by the Healthcare Authority in this case. You have that in front of you.
Are you asking me if I have that?
Ask you if you have that, if you recognize it as an email exchange, but that concludes with an email to Nancy Nesser.
It appears to be.
All right, and Your Honor, we'd offer 1165 into evidence, request permission to publish.
No objection.
J 1165 will be admitted into the evidence. Permission granted.
So if you look at the middle email on the first page, we see that there's an email from Sherry Dulworth of CMT Healthcare to Ms. Nesser, correct?
They had a different one up on the screen. She's fixing it.
Okay, there we go. We got both of them there now.
Yes, I see that.
And it's had forwarded some data, but the response to the presentation of the data is sent from Ms. Nesser to Shelley Gorman and to Chris Lay, right?
It appears to be.
And Ms. Nesser's comment on the data is that she doesn't think the data looks that bad. They get data on all non-duals in our program. So I think what we have here is a hydrocodone problem, and maybe not so much on the long-acting products. Now, Duragesic is a long-acting opioid, correct?
I believe that's true.
All right. Let me approach, Your Honor.
You may.
The rest of the sentence says it didn't screen out for diagnoses, so this includes all cancer patients as well.
It does say that, yes. Now, this is the meeting packet for the following month, September of 2009, for the Drug Utilization Review Board, correct?
Yes.
Your Honor, we offer 1171 into evidence, request permission to publish.
No objection.
J 1171 will be admitted into the evidence. You may publish.
And if you turn to page 7, you there?
Yes.
And actually, if you look at the top of page 6, you'll see that what we are looking at are the minutes from the meeting of August 12, 2009, correct?
Yes, and I see my friend Richard there too.
Yes, Mr. Ponder attended a number of these meetings over the years, and as we court the scene, and he testified to that and to what went on at those meetings. The agenda item number 6 on page 7.
Yes.
We see vote to apply quantity restrictions to hydrocodone products, right?
I see that.
And we see the action motion carried. And what we see here is Dr. Weingartner moved to amend the recommendations submitted, deleting tablets per day quantity limit, seconded by Dr. Faitner, right?
It says that?
So what happened was they voted to reject the quantity limit for hydrocodone that had been recommended in the August packet that we looked at previously.
Because the only thing in that recommendation was a tablet per day quantity limit, is that what you're saying?
I'm saying there were 3 recommendations we looked at, one of which was to impose a quantity limit similar to the quantity limit that we looked at for, I believe it was carisoprodol on the chart, right? We can go back to it if you want.
It would help me. Sorry, I just want to make sure that I understand what you're asking me.
Sure, we can go back to 1160.
Which page?
Page 26 of 1160. If we can bring that up, Ms. Conway. And you see there were 3 recommendations, right?
Yes.
And if you turn back to page 7 of 1171, you'll see that what the board did was voted to amend the recommendations submitted, deleting the tablets per day quantity limit, right?
So this is saying that they enacted recommendation 1 and recommendation 3, but deleted recommendation 2. Is that what you're saying?
Correct.
Yes.
And they deleted the quantity limit.
Yes, that's what it looks like to me. Looks like they did 1 and 3 and deleted 2.
Okay. One of the other things we see in this meeting packet from 2009.
So put the old one away and stay on the one you just gave me, right?
Yes, that's right. And if you turn forward to page 48. We see down at the bottom of that page market updates, right?
Yes, I see that.
And we see a reference there to Nucynta.
I see that.
To Pentadol,
Yes,
approved November 20th, 2008, available July of 2009, correct?
I see that.
And you understand that's the immediate release form of Nucynta?
I believe that's correct.
Okay, and if you turn to page 50, we see where Nucynta was placed in the formulary. It's in the tier 2 column. down at the bottom, the coloring is original to the document.
Sorry, do you want to say that one more time?
Sure, I was just saying that the coloring in the document is in the original
No, the
document.
first part is what I missed. There's some noise back there.
Down at the bottom, we see tapentadol, Nucynta,
Mm-hmm.
under short-acting, tier 2, correct?
Mm-hmm.
All right. May I approach you?
Yes, you may.
Let's go to 2942B. Your Honor, this is a separate part of the exhibit referenced earlier. We marked 2942A, and now we're going to mark this as J2942B. If that's all right.
Yes, Mr. Whitten, you're okay with that? too?
No objection.
Now, Ms. White, I've handed you a copy of what's marked as 2942B. This is a complaint in and before the Oklahoma State Board of Medical Licensure and Supervision, State of Oklahoma versus Dennis Roberts, MD. Do you have that?
I do.
And it's dated March 22nd, or stamped March 22nd, 2013, correct?
Yes.
And Your Honor, we would offer this into evidence and request permission to publish.
J2942B will be admitted into the evidence, and you may publish.
Thank you. Now, I want to start by pointing you to paragraph 3. And we see on October 11th, 2010, an Oklahoma licensed medical doctor filed a complaint alleging large-scale inappropriate prescribing by the defendant, Dr. Roberts. You there?
I see that.
And then we see about a month later, on or around November 15th, 2010, a complaint was filed by CB, mother of adult patient RB, alleging defendant provided her son increasing amounts of controlled dangerous substances which contributed to the death of her son. Do you see that?
I do see that.
Did the state inform Janssen of these complaints about Dr. Roberts when they were made in 2010?
I don't know.
Now, these complaints, if we go down to the next paragraph, allegedly led a board investigator Lane, to speak with Dr. Roberts on 3 different occasions about his prescribing habits and to educate him of possible prescribing red flags, such as prescribing with spouses or parents and children the same medications. And also reminded Dr. Roberts that narcotic abuse was an epidemic and of the importance of proper charting, right?
It says that.
All right. Now, if we continue on, we see that
The last sentence of
Paragraph
that
6.
paragraph, though, is important as well. You didn't read the whole paragraph.
well, I want to go on to paragraph 6. We can, I'm sure Mr. Whitten will have the opportunity to read things that I skip over, but if we read every paragraph and we go through the whole thing, and if we read every sentence in all of these, we're going to be here longer than I think anyone really hopes.
I just wanted to make sure we didn't leave out something that was important to make the paragraph complete.
All right, so if we go to paragraph 6, and you're referring that they gave them the prescribing guidelines. chronic pain prescribing.
I'm specifically talking about the fact that they gave him, it says, he was provided the chronic pain guidelines from this board.
Right, from the board investigator. All right. So we flash forward to January of 2012, right?
I see that.
And we see that at that point, Dr. Roberts advised the investigator that he was formerly with Integris Family Southwest, but had a disagreement with fellow physicians who were concerned about Dr. Myers overprescribing controlled dangerous substances, right?
I see that.
And this apparently prompted the investigator to obtain medical records from some of Dr. Roberts' patients, as well as pharmacy records showing what those patients had received, right?
I see that.
But again, at this point in time, did the board advise Janssen of its concerns that prompted the investigation of this doctor?
I don't know.
All right, let's go forward to paragraph 9. And we see there, if we can bring that out, Ms. Conway, that the board had completed, a board expert had completed his review of the medical records.
When you say that, I've never testified before, so help me understand. When you read a sentence and you don't ask me anything, but you're silent, do you want me to say if the sentence says that? Or do you want me to wait for you to ask the next question?
It was sort of a question.
Okay.
We see there that the board investigator reported that the board expert on about August 21st, 2012, completed his review of the 5 medical records. And those are the 5 medical records by initial that we saw referenced in paragraphs 6 and 7, right?
I believe
7 and 8, sorry.
I believe that's correct.
And the expert's overall summary indicated that in every case there was definitely an overprescription of controlled medications, most times 450 to 520 tablets every 3 to 4 weeks, right?
It says that?
And further down, the expert concluded there were no documented discussions of the potential hazards of the medications in the quantities prescribed, right?
I see that.
And very little monitoring was done through the OBN or with labs, and if they were done, nothing was done with the results. And continuing on to the next page, we see a bolded conclusion from the investigator. I find it appalling that a 22-year-old patient went from a 15-tablet Lortab prescription to 420, it says tables, presumably tablets, of controlled medications within 4 months with no apparent reason. And then she was involved in a motor vehicle accident, right?
I see that.
And when these conclusions came out in August of 2012 from the board's expert, did the state advise Janssen of these concerns about Dr. Roberts' prescribing?
I don't know.
All right. Now let's move forward to paragraph 11. And we see that around July of 2012, a patient filed a complaint about Dr. Roberts' prescribing of the medication Ultram while she was breastfeeding an opioid-addicted newborn. You see that?
You said, I think what you just asked me is if a patient filed the complaint. I don't know that JS was a patient. JS may have been. What it says is JS was married to the patient. So I don't know if JS is a patient or not.
So the patient's husband, patient AS's husband, JS filed a complaint in July of 2012 about Dr. Roberts' prescribing of Ultram, right?
That's what it says?
And at this time, when concerns were raised about prescribing that much Ultram to a pregnant patient, did the state come to Janssen and advise Janssen of that complaint?
I don't know if they did or not.
Not something that you looked at in preparation for the testimony you gave yesterday?
Did I go look to see when the state called Janssen when I already knew that Janssen purchases the prescribing records of all the docs and targets doctors based on those prescribing records? No, I didn't feel that I needed to go look at that because I felt like Janssen already knew.
And you didn't look at whether the state provided Janssen any information about complaints that were raised about Dr. Roberts' prescribing, did you?
I did not feel like that was something I needed to look at based on what I knew about the information Janssen acquired of doctors prescribing some prescriptions. No, I did not.
Now, Ms. White, you're not an expert in what's available in IMS data, are you?
Am I an expert in IMS data? I don't know legally if I'm an expert in IMS data, but I'm aware of what that's a legal question, but I'm aware that IMS data exists and about it.
And I assume, however, you're not an expert in what is available regarding specific prescriptions to individual patients within IMS data. Fair?
I've had conversations actually with some of the individuals who actually sell the IMS data. I don't know if they've told me that or not. I don't know if in looking at it before and talking with them, I could answer that for sure.
All right, so sitting here today, you're not aware of the breadth of the window that IMS data provides into prescribing for individual patients, are you?
I don't know if I could fully describe the entire breadth of what they provide.
All right. Let's shift gears a little bit and go back to the PMP. And Your Honor, I can keep plowing through, or we can break now before we jump into this.
Let's go ahead and take a break. I'd like to resume back at 10:20.
Thank you.
All right. to begin. I would like to stop at noon, and I understand that there may be a motion that you'd like for me to take, hold a hearing on when we get back from our lunch break.
I just gave a copy. Mr. Witten told me I served the wrong attorney on their side. I'm trying to figure out who to serve you on.
He thinks I read it.
I'm sure between now and 1:30 they'll find someone that can read it.
It's just safe hands.
Says Miss Baldwin. We know who to give it to now.
Thank you.
Your Honor, if I may approach on resuming here.
Yes.
Thank you. Okay with that?
Thank you.
And Ms. White, I've handed you a copy of a document we've marked as Exhibit J514. Do you have that?
I do.
This is an OBN presentation on the Oklahoma PMP system that was produced to us by the state in this case. And Your Honor, we would offer J514 as an exhibit.
No objection.
Request permission to publish.
J514 will be admitted into the evidence, and yes, you may publish.
And Ms. White, if you see on the second page of this document, we see a brief history of Oklahoma's PMP, right?
Yes. Do you know what year this was from by chance? You may not, but I'm just curious because it doesn't say.
I believe this is post 2012
Okay.
because it contains information about events that occur going up to at least 2012.
Okay.
So we see here that the PMP in the form of the OSTAR system, as we discussed, began collection of Schedule II data in 1989, right?
Yes.
And that it began collection of it was already collecting Schedule II, expanded through Schedule V in 2006, right?
Yes.
And we saw that referenced in the document from OBN relating to system upgrades yesterday, correct?
I think so.
And we see that the web portal was launched in July of 2006, right?
It says that.
And then we see at the bottom, after some system enhancements running up through 2012, beginning in 2012, the PMP system will provide doctors and pharmacists access to prescription information immediately after it is delivered to patients or their designee, right?
Yeah, I think this is talking about one of the things that our state is leading the way on in PMP is the real-time availability, whereas in most states you have anywhere from a week to a 30-day lag between when a prescription's filled and when the data actually goes into the PMP. And I think what they're highlighting here, although I have not seen this document before, is the real-time data in our system.
Right, because up until 2012, real-time availability of data didn't exist within the PMP, and that's what this is highlighting, the fact that is a change that is going to be made to have that immediate information available in the PMP beginning in 2012, right?
I actually don't think that's correct. I think if I'm remembering correctly, Oklahoma was leading the nation in the PMP, and we had a PMP that had data available within 24 hours, which was considered real time, which was the national standard. And then we upped it even further in 2012 to real time. I think it's 5 minutes or less and might be more immediate. But no, I believe we had the system that was considered real time even prior to 2012.
But up until 2012, as OBN itself observes here, there was not immediate availability of immediate access to prescriptions for doctors and pharmacists, correct?
And it sounds like it, or it is the case that in 2012, we went from what was considered real time, and it was the fastest system in the United States at 24 hours, and then we upped the ante even further to with immediate access.
And if you turn to page 7, you'll see some of the positive impacts that the PMP had on doctor shopping, including, excuse me, a 70% reduction in doctor shopping in 2.5 years, right?
Sorry, I hadn't seen this before, so let me catch up. Okay, sorry, what was your question?
My question is that we see on page 7, one of the benefits in the form of a 70% reduction in doctor shopping in 2.5 years, correct?
It says that?
But of course, one of the things that OBN recognized is that the PMP existing on its own would not be enough. It must be supplemented by aggressive enforcement action for full effectiveness, correct?
That is what this says?
All right. Now, let's talk a little bit more about enforcement. If I may approach, Your Honor.
You may.
600.
Thank you.
Ms. White, I've handed you a copy of what we've marked as Exhibit J600, and this is a stipulation and agreed order before the State Bureau of Narcotics and Dangerous Drugs Control, State of Oklahoma versus Mickey Ray Terrell, MD, correct?
Yes, I believe so.
And Your Honor, we offer J600 and request permission to publish.
Objection.
J600 will be admitted into the evidence. You may publish.
Thank you. And you see this is stamped on June 2nd, 2011, correct?
Yes.
And it contains findings of fact. Ms. Conway, if we can bring those out. And in the findings of fact, the Bureau of Narcotics said there were facts or omissions from which it could find or conclude that Dr. Terrell committed prescribing violations or failed to maintain the proper record information of the controlled substances prescribed regarding patient TD during a period of approximately 3 months from the end of June 2009 until patient TD's death as a result of an overdose of the prescribed controlled substance at the beginning of September 2009, which would constitute a violation of the rules of registration and Oklahoma law, correct?
Yes, it says that.
And do you know whether the state informed Janssen of concerns about Dr. Terrell's prescribing during the course of this investigation?
I do not.
All right, let's look at the agreed order. If you turn to the next page. We see that based on the findings of fact and conclusions of law, the director orders, excuse me, that Dr. Terrell has agreed not to prescribe any drug for which OBN registration is required for a period of 30 days, beginning on June 15th and extending to July 15th of 2011, and that the director accepts Dr. Terrell's agreement on that, and he is to pay an administrative fine of $8,000, right?
Yes, it says that.
And that 30-day suspension in 2011, do you think that that is a sufficient suspension in order to address overprescribing, the kinds of overprescribing of opioids that you believe led to the opioid crisis?
I object that asking her to comment on this is inappropriate. She is not the director, Darrell Weaver was.
I'm not asking her for a legal opinion, Your Honor. She gave extensive opinions on causation, and I'm asking her whether this kind of 30-day suspension is short to the point where it's a contributor to the opioid crisis that Oklahoma has endured.
That's not what he asked. He's a roundabout way of asking the same thing.
I sustain the objection.
Let me ask you this, Ms. White. Did you look into the question of and the issue of decisions made regarding physician misconduct in the course of your preparation to come to testify in court and offer the opinions that you offered on Mr. Whitten's examination yesterday?
Ask me that again, I'm sorry. I'm trying to follow you.
Sure. Did you look into the issue of penalties for physician opioid prescribing misconduct in the course of your preparation to come to court and offer opinions on causes of the opioid crisis in Oklahoma?
Did I look at physician penalties as the cause of the opioid crisis in Oklahoma?
Did you investigate that question as part of your preparation to come to court to offer opinions on causes of the opioid crisis in Oklahoma?
Certainly I'm aware of some of that generally there are physicians who were pursued by the Attorney General and by the Bureau of Narcotics. You've shown me some today. Did I spend time investigating that? No, we had I don't believe so. Now, I had conversations with the medical licensure boards, as you see in the abatement plan, about their ability and desire to do more, and part of the need for that in the abatement plan. But I'm not sure when you say penalties as the cause, I don't think I did, but I'm not sure I'm completely understanding your question.
One part of doing more would be to impose more significant penalties and to take away the rights of doctors who misprescribe opioids to continue prescribing them, right?
Same question. He's asking the commissioner to opine on what the penalties should be. In a hindsight analysis, that's not her job to do. That's inappropriate.
Your Honor, she indicated that one of the things she looked at in connection with abatement is what the boards might do in order to, the words she used were do more. I think it's a fair question.
He brought that up. Now he's complaining that she addressed his first question.
I sustain the objection.
All right, let's continue through. Let's continue through our timeline here. And if I may approach, Your Honor.
You may.
And let's go to 1550. Give us a moment, Connor.
Sure.
Thank you.
So, Ms. White, I've handed you the meeting packet for the February 13th, 2013 Drug Utilization Review Board meeting. Do you have that?
Yes, I do.
And Your Honor, we offer 1515 and request permission to publish.
No objection.
J 1515 will be admitted into the evidence. You may publish.
And Ms. White, if you turn to the second page, you'll see the meeting packet enclosures. You there?
Yes.
And you see Appendix F is the fiscal year 2012 annual review of narcotic analgesics. See that?
Yes.
And I want you to go to the start of that, page 28. You there?
Not quite. I am.
And this is from the Oklahoma Healthcare Authority dated February 2013, right?
Yes, that's what it says.
And we see at the very beginning, it indicates that this initial review was presented amidst concerns excuse me, of increasing rates of prescription drug abuse juxtaposed with the need to provide adequate pain relief for Sooner Care members, right? Second sentence.
Sorry. Yes, I see that.
And they observe in this document some of the problems that were impacting Oklahoma at that time, right?
I haven't read it. Do you want me to read it and tell you if I think
Well,
that?
specifically, I'm looking at the last sentence of the second paragraph where they observed that according to the NSDUH survey with data for the 2009 to 2010 period, Oklahoma ranked highest in the nation with rates of overall rates exceeding 7% and rates as high as 15% in the 18 to 25-year-old age group of persons reporting having used pain relievers for non-medical purposes, right?
Yes, it does say we ranked highest in the nation.
Right, and that's for non-medical use of pain relievers, correct?
It is.
And what we see here is, if we scroll a little bit further down, Ms. Conway, a reference to steps that have been taken by the healthcare authority in order to try to address that issue over time, right?
It appears to be highlighting some of their steps.
And we've actually looked at a number of these. We looked at the July 2008 imposition of the prior authorization tiers for narcotic analgesics, correct?
If you say we looked at it, I will believe you.
Those were the 3 tiers in the formulary, placing the different drugs in the different categories within the formulary that we looked at before the break.
Yes.
And we saw the hydrocodone ingredient duplication edit before the break where the board voted to delete the quantity limit portion of that proposal, right?
That was either recommendation 1 or 3 is what you're telling me?
Correct, that was recommendation 1.
Yes.
And then we see some subsequent steps that were taken subsequent to that, right?
Yes.
All right, now if you turn to page 32, by the way, if we can flip back for 1 second, Ms. Conway. We see that in May 2011,
Where am I flipping back to?
back to page 28.
Oh, sorry.
We have it up on the screen for you. We see in May 2011 that Suboxone, buprenorphine, was placed on prior authorization, correct?
I see that.
And you understand that Suboxone is used as part of MAT, medication-assisted therapy, right?
It is.
And so what the healthcare authority did in 2011 was impose a restriction on the ability of a physician to prescribe Suboxone, right?
That's what it says.
All right, so let's go forward to page 32. And I want to look at the first chart there, if I may approach the screen, Your Honor.
You may.
Now, you recall, Ms. White, we just looked at July of 2008 when the prior authorization formulary tier system was finally imposed by the healthcare authority on the recommendation from the board,
I remember that.
and that was in 2008.
I believe so.
And as you saw there, what happened is a number of the extended release medications, including Duragesic, were placed into tier 2, right?
Mhm.
And the immediate release opioid products were placed as a group, except for a couple exceptions, into tier 1, right?
I think so.
And what this shows is upon the imposition of that control, that claims through the Medicaid program for extended release drugs dropped first to the level of immediate release, and then we see a separation over time through November of 2012 with a general rise in claims for immediate release formulations and maintaining that lower level of extended release formulations that were in existence from the time that the tier system was authorized, right?
Yes, I'm just trying to figure out, because it looks like you scaled extended release and immediate release different, and so I just wonder if it was scaled correctly. I don't think, if it was scaled the same way, I don't think what you'd see is the blue line going below the brown line and the brown line going above the blue line. The blue line would be way down here, and the brown line would be right there. So I feel like it's a little strange to try to show me that they're crossing when they're not on the same scale.
Well, if we have questions about the scaling, we would have to address those questions to the healthcare authority, wouldn't we?
We could certainly ask the healthcare authority, but I'm saying you're asking me a question about it, and I'm telling you that my impression of this chart is that it's scaled in a way that may give an impression that I'm not sure is accurate, regardless of who made the chart.
And you're referring to the fact that obviously the numbers of immediate release prescriptions are so much higher than the number of extended release prescriptions that you choose a scale on one side, right? You choose a scale on the other side, and based on the scale you choose, it's going to impact where the different lines appear on the screen, right?
If you're asking me, am I saying that because the scales are different on both sides, it changes where the lines appear? Yes.
Right, and I assume that was the point you were making, is that
Yes.
the scaling impacts where the lines appear, right?
Yes.
But what the scaling doesn't impact is the fact that the data presented by OHCA shows that immediate release claims went from a level between approximately 30 and 35,000, and that's per month, right?
I believe so.
To the 40 to 45,000 range in the months following the inception of prior authorization tiers, right?
I believe so.
And what it also tells you is that extended release claims fell from a peak in the 3,000 to 3,500 per month range to the 2,000 to 2,500 range over that time period, correct?
There was a peak in, looks like in 2005, but most of the time it looks like they were somewhere between the 2,500 and the 3,000 range. And it went to the 20, looks like stayed most of the time around the 2,200 range.
So you said the peak was 2005. I think you meant May 2008.
Yes, I did. I'm sorry. I saw the 05. Thank you.
All right, thank you. And so here again, we see the impact of payor decision-making on prescribing, don't we?
I think that's possible.
Now I want to stick with this document. If you would, turn to page 37.
But honestly, on that chart, I'm not sure that's what that shows, that it shows payer impact in this particular chart. I'm not disagreeing you that payer impact happens, but that chart is really, if scaled correctly, showing there's not significant change in long-acting, and there's a continued increase in prescribing of short-acting, or whatever those are called. Sorry, I'm not using the right word. And I think what this is showing is we continue to have a problem with the prescribing of opioids going up.
Let's just kind of wait if we can pull that out again. So what we see here is in January of 2007 and call it July of 2007, that immediate release formulations were relatively constant. There's some variation in that 2,000 to 2,500, I'm sorry, the 30,000 to 35,000 prescriptions per month range, right?
Well, what I think it shows is that from 2007 to 2012, as I think we're saying the same thing, prescribing of opioids keeps going up in the state of Oklahoma.
For the immediate release formulations.
Correct. And then I think for the blue line, what it's showing from 2007 to 2011 is there's not a significant change. If you look at where it started in 2007 at 2,500, it ends at about 2,200. If you draw that trend line, I don't think there's a significant change.
So,
there is this anomaly that I talked about that I thought was 05 and you pointed out was 08, and I appreciate you correcting it, but that's not indicative of what this shows over time. If you look at the trend line, it will go from 2,500 to about 2,200.
so if we take the midpoint, obviously we don't have exact numbers.
Right.
It'd be easier to do percentages with exact numbers. What we do see is from May of 2005 to the first month after prior authorization requirement was put in place, May of 2008, the same thing.
Thank you. I'm sorry. I probably did that to you.
To August of 2008, we see an immediate decline of about 1,000 prescriptions a month, correct? In this time period.
That is true, but when you're looking at this chart as a whole, you wouldn't, and when you use data in general, you don't take this one outlier and say this is indicative of what it's showing when it's clearly not showing that. If you draw the trend line from 2007 to 2012 for ER claims, the blue line, it's going to go from about 2,500 to about 2,200.
And if we take the immediate impact of the imposition of the prior authorization requirement, I think we can agree that going from 3,250 prescriptions a month to 2,250 prescriptions a month is almost a 33% decrease in the prescribing of extended release opioid medications to Medicaid patients, right?
If you're talking about the immediate impact, you would actually use the 2008-07 number to the 2008-09 number, and it would be 2,700 to 2,200.
Which would be 500, which would be 17% reduction in the number of claims in a single month, correct?
Right, that's correct.
All right, let's go to page 37.
Page 37 in this?
Yes, same document.
Thank you.
And we see a recognition of the impact of some of the steps that were finally taken in the discussion here, right?
I'm not going to say right to that. I take issue with you saying finally, as you've heard me testify earlier. When someone's coming up, and it was a question asked directly to me, if someone comes up and hits you in the back of the head and you respond when you wake up, if you've been knocked out, I wouldn't describe that as finally, but if you want to ask me if this is a summary of actions that were taken and the results, I'm happy to talk about that. But when you put in the word finally, I can't say yes to what you just said.
Well, what the Healthcare Authority observed was the data had indicated a decline in prescription drug abuse rates in the state of Oklahoma over the prior 3 years, right?
It does say that.
And we see, however, if we go further down the page, that there were still things that the state knew it had yet to do, correct? And we look at the next paragraph. You there?
I'm looking. I'm trying to catch up with the paragraph, but there are definitely things we still want to do in the state to deal with the opioid crisis, if that's what you're asking me.
And at this time, 2013, what the Healthcare Authority observed is that although quantity limits are in place for all hydrocodone products containing acetaminophen, these quantities are fairly liberal, allowing up to 240 tablets for a 30-day supply on certain strengths, correct?
I see that.
All right. So let's talk about the chart that we see here, which addresses the source where pain relievers were obtained for most recent non-medical use among the past year. And we see the recognition that free from a friend or relative is the primary source, correct?
Hold on, I'm trying to catch up and read the chart. Do you know what the source of this chart is?
It's the Healthcare Authority is the best I can do for you.
I see that they printed the chart. I'm just curious where they got this information, if you need the source for that. It's okay if you don't, I'm trying to figure out the source.
My question is simply the primary place where pain relievers were obtained for non-medical use was from a friend or relative, 54.2%, correct?
That's what this chart says.
So if you turn to page 39, there are some recommendations from the College of Pharmacy, and I want to focus on quantity limits.
On page 39?
Correct. And here you see the College of Pharmacy recommended the consideration of other management strategies, such as lower quantity limits on immediate release products, correct?
It says that?
And here we see require use of the Oklahoma Prescription Monitoring Program for all prescribers who prescribe narcotics, correct?
I see that.
And this was in February of 2013, correct?
Yes, and I believe, as I testified to yesterday, the state plan that I had tasked the Prescription Drug Working Group to develop had already come out, and that recommendation was in there. So I see it reprinted here.
And it was another 2 years, I believe, before that requirement was implemented, correct?
It went into effect in 2015, yes.
If I may approach, Your Honor?
Yes, you may.
Let's go to 594.
Thank you.
Ms. White, I've handed you a copy of what we've marked as Exhibit 594. It's a letter to Dr. Harvey Jenkins. Do you have that?
I do.
And it's the ray line, the subject line is immediate suspension due to imminent danger, right?
It does say that.
Your Honor, we offer J594 into evidence.
No objection.
J594 will be admitted into the evidence.
And may we publish?
Yes, you may.
And what this does is it notifies Dr. Jenkins that his privileges to prescribe, possess, administer, dispense, schedule, control dangerous substances is immediately suspended, right?
That's what it says?
And so in February 2015, the Oklahoma Bureau of Narcotics determined that Dr. Jenkins was an imminent danger to Oklahomans such that it warranted an immediate suspension of his ability to prescribe drugs, correct?
I'm sorry, say that one more time. I was trying to find what you were reading, but you may have just been asking me a question. You may not have been reading something.
Well, it indicates that we can blow out that first paragraph. That his prescribing, continued prescribing, would constitute an imminent danger to the public health, safety, and welfare of the citizens of Oklahoma, correct?
I see that.
But the state of Oklahoma knew well before 2015 that Dr. Jenkins was engaging in improper conduct related to opioids, correct?
That we knew prior to 2015?
That's right.
Did you show me that already?
That's just a question first,
I don't know.
not something you looked at in connection with your preparation to testify, right?
The first time I remember hearing about Harvey Jenkins was around 2015, but I don't know if other people knew something before that.
Okay, and you didn't take any steps in preparing to testify and offer your causation opinions to the court to figure out what the state might have known about Dr. Jenkins before you first heard about him in 2015, right?
No, I did not go try to find out what the state knew and when.
All right, if you turn to page 2, please. You see the indication in the first full paragraph. Respondent was disciplined by the Oklahoma Medical Board and the Oklahoma Bureau of Narcotics in 2011, wherein Dr. Jenkins stipulated that he had abused and/or excessively used controlled dangerous substances and that he prescribed them for his own use, right?
I see that.
He was again disciplined in 2014, January 2014, for engaging, this is the next paragraph, in prescribing or administering a drug or treatment without sufficient examination and the establishment of a valid physician-patient relationship, right?
I see that.
At any point during this time period, did the state of Oklahoma reach out to Janssen or any other opioid manufacturer and advise them of the actions that had been taken against Dr. Jenkins?
So if I remember correctly, we've seen during this trial a series of call notes where Janssen was calling on Dr. Jenkins repeatedly. And so you're asking me if the state of Oklahoma called your sales reps who were calling on Dr. Jenkins because he was a target for you, to prescribe more, to ask you if you knew that he was a high prescriber? Is that what you're asking me?
Well, you've restated my question, but I think you understand what the question was. And the question was, did the state reach out during this time period when it had this information, 2011 all the way up through 2015, about Dr. Jenkins, to advise Janssen of the disciplinary actions taken as a result of the unprofessional conduct by Dr. Jenkins?
What I know is that the state was not notified by Janssen that you had targeted Harvey Jenkins because he was a high prescriber, encouraging him to sell more. I know that didn't happen. I don't know if the state called Janssen & Janssen to make sure that as you were continuing to send your sales reps out, which we didn't know about and hadn't been told, and pushing Harvey Jenkins to prescribe more, I don't know if the state called to tell Janssen & Janssen that that was happening. I don't know.
Did the state advise any opioid manufacturer of its concerns about Dr. Jenkins?
I do not know.
And you didn't look at that in connection with your preparation to offer causation opinions to the court?
I didn't feel that I needed to look to see if Janssen was notified by the state of Harvey Jenkins prescribing, given that I knew how hard Harvey Jenkins had been targeted by Janssen.
How many Nucynta prescriptions did Dr. Jenkins write during this time period?
I don't know the number of scripts.
All right, you're on a minute approach?
Yes, ma'am.
Thank you.
Ms. White, I've handed you a copy of what we've marked as Exhibit J298. This is a final order before the State Bureau of Narcotics dated June 15th, 2015 in the state of Oklahoma versus Harvey Jenkins, MD. Do you see that?
I do.
Your Honor, we offer J298 into evidence.
J298 will be admitted into the evidence.
May we publish, Your Honor?
Yes, you may.
And if you look at the final order, you'll see that it was issued following the imminent danger hearing on the letter that we were just looking at, right?
I'm sorry. Can you say it one more time?
Sure. It indicates that the final order came on for an administrative, is issued after the matter came on for an administrative hearing on an order to show cause that followed a February 2015 imminent danger hearing, correct?
It looks like that's what this says.
And the imminent danger finding was contained in the letter to Dr. Jenkins that we just looked at before this document, correct?
I believe so.
All right, and if we turn to page 74, I'm sorry, paragraph 74, which is on page 13. You there?
I am.
And this is a reference to Medical Board Investigator Jana Lane, correct?
Where are you seeing that name? I'm sorry. I'm supposed to look at 74.
It's actually right above paragraph 73. You see Medical Investigator Jana Lane, and then there is a summary in which paragraph 74 is included. Do you see that in the document?
Yes, I do now. Thank you.
And there's an indication that Ms. Lane, who apparently is a nurse, a registered nurse, is aware that Dr. Jenkins was placed on probation with the medical board as a result of a urinalysis coming up positive for oxycodone in February of 2011.
I'm trying to follow along. Tell me where it's talking about Jan Elaine being a registered nurse. Oh, right there, in 73? Are we back at 73 now?
Yep, and we were reading from 74, the first sentence.
Right, so I'm reading along with you here, up on the screen. And then what you just asked me is if Jan Elaine was a registered nurse, and I don't see that, but if you look back at 73, then I saw it. So I'm trying to follow you here instead of here.
Perfect. Well, we can follow on the board.
Okay,
And if I'm going to ask you to look at something in the document, I'll let you know, okay?
okay.
I just think it's easier if we blow it up for everyone to
I
follow.
agree, I can read it much easier. It's just that you said some things I didn't know if she was a registered nurse or not, so I had to look back.
All right, thank you for that. And this is a reference to the probation that Dr. Jenkins was put on for abusing oxycodone, correct?
That's what it looks like.
All right, and if we look at the fact he was put on 3 years probation, his ability to prescribe controlled substances to patients was not restricted, was it?
It doesn't say here. Is that what you're asking me?
Correct.
It doesn't say here.
All right. Do you know if when Dr. Jenkins was put on probation, there was any restriction on his ability to continue to prescribe controlled dangerous substances?
I don't know.
All right. But we saw from the letter we looked at previously that he ran into some trouble in 2014, before November of 2014, related to his overprescribing, didn't we?
We did see a letter that said that.
All right. It wasn't just the Bureau of Narcotics that was aware of the problems in Dr. Jenkins' practice, was it?
I assume you want me to say no, but I don't know.
Okay, so you didn't look into whether the Attorney General's Medicaid Fraud Control Unit was investigating Dr. Jenkins on a referral from the Healthcare Authority beginning in 2012?
No, I did not look into that.
Right. But what you do, what you can say is you're aware of no evidence that at that time anybody in the Attorney General's office notified anyone at Janssen of the concerns with Dr. Jenkins' prescribing, right?
I feel like we have had this conversation, but I'm happy to reiterate that I think where it's very clear that Dr. Jenkins was an important target to Janssen & Janssen, visited many times, encouraged to prescribe, that Janssen & Janssen was aware of his prescribing, and so I did not go look to see if the Attorney General told the Janssen & Janssen reps who were calling on him repeatedly that Dr. Jenkins was a high prescriber.
That wasn't my question. And I moved to strike the response.
I'll strike the response.
Thank you. My question is, you're not aware of any time when the Attorney General's office advised Janssen that it was investigating Dr. Jenkins for Medicaid fraud related to his prescribing, are you?
I do not know if the Attorney General's office advised the sales reps from J&J that were repeatedly called on him that they were investigating, excuse me, that their Medicaid fraud unit was investigating Dr. Jenkins. I do not know.
All right. And likewise, you don't know whether Janssen knew that Dr. Jenkins had tested positive for oxycodone abuse and had been placed on probation, right?
I don't know if Dr. Jenkins and Janssen & Jansson's sales reps discussed that or not.
And let's look back at page 4 of the document you have in front of you.
Page 4?
Yes. For the record, that's page 4 of page 298. And you see there's a reference on page 4 to OBN agent Brian Talent, right? It's highlighted on the screen.
Oh, thank you. Oh, yes, sorry, I was reading the numbers, I'm sorry.
And then under that heading, if you continue on to the next page, you see paragraph 23, that he, Brian Talon, became involved in the investigation in 2013 when the Bureau of Narcotics was requested by the Attorney General's office to assist them with the Medicaid fraud investigation that I referenced by conducting undercover operations, right?
I see that.
And it indicates that a few days later, he went into Dr. Jenkins's office to make an appointment as a new patient, right?
It says that.
He was told that the initial visit would cost $550, given a brief history document that appeared to be a pain contract, and told to bring his records with him, right?
That's what it says?
And if we skip down to paragraph 26, he details the fact that he arrived as requested, observed a number of the people who were around him, and then in paragraph 29, he states he did not bring any medical records with him, right?
Correct.
And the summary of his investigation continues, and I want you to move forward. You see in paragraph 27, he confirmed that when he went there, he didn't really have anything physically wrong with him. His back was in good shape, he didn't have pain that day, and that he had passed physical fitness tests for his job twice a year, right?
Yes, it says that.
And then he was required to have a follow-up appointment approximately 2 weeks later. He arrived at the front desk, paid another $250, and received the billing paperwork, which stated that he was there with a cervical injury. And he told them it was supposed to be low back, right?
It says that.
They didn't take any vitals. He was basically just, this is paragraph 45, in and out of the room with the female who examined him. See that?
Yes, I see that.
So if you would, if you still have it there, flip back to J594. And you see a reference on page 4 at the bottom. You see a reference to Agent BT, Brian Talent there, right?
I see that it says BT, yes.
And it indicates that he and another agent went to Dr. Jenkins' office on multiple occasions and were prescribed either Schedule 2 or Schedule 3 controlled dangerous substances without providing any medical records, diagnostic testing, or an adequate medical exam. Correct?
I see that.
And that was in 2013, right?
I believe so.
And even at that point in time, neither the Bureau of Narcotics nor the Attorney General's office notified Janssen or any other pharmaceutical manufacturer of what they had learned about Dr. Jenkins' practice, correct?
What you had me read on line 23, or what you read to me, was that the Oklahoma Attorney General's office on July 10th, 2013 had contacted OBN to assist them with a undercover operation. No, I do not know if they chose to let Janssen and Janssen know about their undercover operations.
And so that's a no, they did not, correct?
No, it wasn't, I don't know if they chose to let Janssen and Janssen know about their undercover operations.
Not something that you looked into. as a part of your preparation to testify, correct?
I feel like you asked me that already in this particular case, and I told you I did not look to see whether or not the Oklahoma Attorney General or the Oklahoma Bureau of Narcotics let Janssen and Johnson Johnson know about, if I looked at it to see if they let him know, or made your sales reps that were targeting Dr. Jenkins aware of this. I don't know. I still don't know. I don't know. I didn't know a few minutes ago. I don't know now.
All right, let's move forward just a little bit in 2013. And I want to talk a little bit about drug diversion prevention. And if I may approach, Your Honor?
You may.
Run out of space down here.
Thank you.
And if you turn past the cover sheet, Ms. White, you'll see that this is a PowerPoint presentation from the Oklahoma State Board of Pharmacy, and the title is the 2013 Drug Diversion Prevention, right?
Yes.
Your Honor, we offer J673 into evidence, request permission to publish.
No objection.
J673 will be admitted into the evidence. Permission granted.
And if you would, turn to page 15 of the document. And you see that what we have here are PMP results for ME, that's medical examiner reports, right?
Sorry, I'm not there. Hold on just a second. I've never seen this before, so give me just a second. Okay, I'm caught up to page, the page you have up, I can't see the page, 15.
Yes. And what we see are PMP results for medical examiner reports for 2008, correct?
That's what it says?
And what the summary indicates is that from those medical examiner reports, 18% of the decedents had seen 5 or more doctors, right?
That's what it says?
According to the data available in the PMP, as the PMP had been updated to include Schedule 2 through 5 drugs in 2006, right?
I believe so.
32% had a prescription, right, at some point in their history.
Correct?
And 61% had no prescription at all, correct?
That of those 18%, is that what you're saying?
Nope.
I don't know if that's what this is saying or not. It doesn't, it's not very clear. I don't know if it's trying to say that 32% of those 18% and 61% of those 18%. I don't know what this is saying.
Well, if 18% of them had seen 5 or more doctors, they wouldn't have a prescription, would they?
If 18% of them had seen 5 or more doctors, they wouldn't have a prescription?
If the PMP reflected that a patient had seen 5 or more doctors and gotten opioid prescriptions, the PMP includes information that shows when a patient fills a prescription, correct?
Correct. The information in the PMP is when a script is filled.
So if somebody had 5 scripts filled, 5 or more scripts filled in the PMP, They wouldn't have no prescription, would they?
I wouldn't think so, but what you were asking me was, what does this 32% and this 61% mean? And I'm saying there's not enough information on this slide that I've never seen until today to tell you what that means. It's not clear.
It is fairly clear, however, that the 32% and the 61% are not a subset of the 18%, correct?
You're asking me to make an assumption about a slide that I've just seen. I don't know what this means. I don't know.
So you're not able to discern, Ms. White, that somebody who has received prescriptions for opioids from 5 or more doctors is not somebody who has no prescription?
I'm able to discern that. What I'm not able to do is make an assumption about what the next two bullets mean.
Okay, well, we can, I guess we could just leave it at that. If you're not able to conclude, well, let me ask you this. So you are able to make that assumption and reach that initial conclusion that somebody who has seen 5 doctors and has prescriptions included in the PMP is not someone without a prescription?
I don't think that's an assumption. If they've seen 5 or more doctors and have filled scripts in the PMP, I don't think that part's an assumption. I'm talking about the assumption of what these next two bullets mean.
All right, thank you. Let's look at another document. Your Honor, if I may approach.
Yes, you may.
510.
Thank you.
Ms. White, I've handed you a copy of what's been marked as Exhibit 510, a document produced by the Bureau of Narcotics in this case. And it's entitled Overview of State Legislative and Policy Initiatives, a 3-part series, right?
Yes.
And if you would,
It's actually entitled Prescription Drug Abuse, Addiction, and Diversions Overview of the State Legislative and Policy Initiatives.
all right, and it's from the National Alliance for Model State Drug Laws and the National Safety Council, correct?
It appears to be.
All right, Your Honor, we'd offer J510.
Your Honor, it's not our document, hearsay, so I would object to this.
Your Honor, it was produced by the Bureau of Narcotics, offering it for the summary that's contained herein. I can simply ask her questions about it. We don't need to admit this into evidence.
That still doesn't make it authentic, and so I think they've got to have a sponsored witness for this.
I'll sustain the objection as to admission, but I'll allow Mr. Brody to ask questions.
Thank you. And Ms. White, just for the record, do you see the sticker, the Bates number at the bottom of this document next to the exhibit sticker?
Is that what OBN hyphen is?
Right, and that's OBN, right?
It says OBN.
All right.
Are you asking me if that's the Bureau of Narcotics?
I'm just asking if it says OBN.
It says OBN.
All right. I want you to turn to page 9. And when you get there, I want you to focus on the bullet, states with pain clinic regulation acts.
Okay, hold on just a second. I have not seen this before, so give me just a minute.
Are you there?
Not quite yet.
It's a very,
Sorry.
it's a very simple question that I want to ask you about this document. And then we can move to the next one, Ms. White. There is a
I'm still trying to figure out what
reference.
the document is. I'm sorry, I've never seen this before.
Why don't you let me ask you a question without reference to the document, then see if we can move
Okay.
this along. First of all, the first page of the document indicates research current through April 2014, right?
The first page,
The cover page says research current through April of 2014, correct?
where do you see that on the first page?
Right under the National Safety Council. Small print.
Oh, no, I can't see that. Hold on. I have a slight astigmatism. Those are not readers, so no, I couldn't see it. Sorry, hold on. Yes, I see that.
It's surprising that I could see it. On page 9, there's a reference to states with pain clinic regulation acts, and it lists.
Are you
9
asking me about the document? Because I thought what you just told me is to stop reading because you're going to ask me a question not about the
I'm
document.
going to ask you a question not about the document, but my question is simply, as of 2014, Oklahoma did not have a state pain clinic regulation act, correct?
I don't know.
Not something you looked at in preparing to testify on causes of the opioid crisis in Oklahoma?
I don't remember.
All right, let's move forward. Stick in 2014, and I want to go back to the Drug Utilization Review Board. If we could get 1644, and if I may approach her.
Yes, you may.
Ms. White, I've handed you a copy of what's been marked as Exhibit J 1644, and this is the packet for the July 9th, 2014 Drug Utilization Review Board meeting, correct?
Yes, I believe so.
Your Honor, we offer J 1644 into evidence.
No objection.
J 1644 will be admitted into the evidence. You may publish.
Thank you. We can pull up the first page, Ms. Conway. And I want you to turn to page 2. You'll see a reference to Appendix B, right?
Yes, I see that.
And that's an update of medication coverage authorization unit, opioid retro DUR, right?
That is what it says.
And I want to go to the opioid retro DUR, and that's page 23, where it begins. And then we're going to flip forward to page 29 of that section.
So you want me to go to 23 and then go to 29? Is that what you're saying?
Well, if you want to stop at 23 and confirm that that's the start of the section, you're welcome to go right to 29. And actually, I want to focus on page 24. I apologize.
That's okay. So go back to page 24. I'm there.
Page 24 contains a section called opioid prescriptions in pregnant women, correct?
Correct.
And if you look at that, you'll see a discussion of study that had been published in the Journal of Obstetrics and Gynecology evaluating the use of prescription opioids in Medicaid-insured pregnant women, correct?
That's what it says?
And if you go further down, there's an indication that codeine and hydrocodone accounted for the majority of opioid prescriptions, right?
Yeah, I think you skipped something important though in that paragraph 2 above where it's talking about the reason pregnant women were given opioids was chronic pain, abdominal pain, lower back pain, headaches, joint pain, and migraines.
Right, and I think that everyone here would agree that a doctor prescribing a pain medication, or any medication actually, to a woman undergoing a pregnancy would have to be extremely careful in weighing the risks and benefits of that, factoring in the potential for there to be harm to the fetus. We can all agree with that, right?
I think that everyone could agree to that. What I'm really quite clear about is that everyone does not agree that doctors should have been told and convinced and pushed to believe that using opioids for these reasons for chronic pain would be a good thing, a necessary thing to do, or that they were adequately told the risks of what it would look like for a pregnant woman to use them for this reason.
And I understand, Ms. White, that you disagree with the extent to which and the conditions for which, speaking more broadly, outside of, as to the whole population, you disagree with the extent to which doctors in Oklahoma and elsewhere have chosen to prescribe opioid medications for their patients over the last 15 or 20 years, right?
I take issue with the way that you word that question, and I won't say right to it. What I've said very clearly is I am very upset about the way that Janssen & Janssen and J&J specifically have tried to convince Oklahoma doctors that these medications are not dangerous and necessary to use for conditions that are listed on this page right here for pregnant women.
So, first of all, Ms. White, I have been here for the entire trial. You're testing my memory, but let me ask you to, if you recall hearing any testimony about Janssen promoting the use of opioid medications for these conditions in pregnant women, because I don't.
I object to that, Your Honor. She has been in the trial. She's also seen discovery materials for their own drug rep called on these people. He knows that. So that's an improper question. And if their sales rep had shown up when subpoenaed, she would have heard it live in the court.
Your Honor, it's a proper question. She just commented on what she believes the evidence is. She's been
I'll overrule
offering-
the objection.
Thank you.
I do believe that we've seen evidence that Janssen and Janssen, or Johnson and Johnson and Janssen, absolutely created the belief and the perception among Oklahomans and Oklahoma physicians that conditions like this were an undertreated and untreated pain need. And I believe that we've heard quite a bit of testimony of the effect that that has had on pregnant women. I cannot remember sitting here at this moment the connection that was made between Johnson & Johnson and Janssen and pregnant women, but I do believe I have seen that evidence in preparation for this trial, and I may have seen it during this trial.
I'm sitting here today, you can't point me to anything came.
I can't sitting here right at this very minute.
All right, thank you. Let's talk a little bit about benzodiazepine and Opioid Use. Okay?
Okay.
And I want you to turn to page 27. Your Honor, for planning purposes, I'm probably going to have about 45 minutes after lunch. You there?
Yes.
And we see the indication there. This is from the Oklahoma Healthcare Authority in July of 2014, right?
Yes.
And if I shorten from benzodiazepine to benzos, will you understand what I'm referring to?
Yes.
We see the introduction here. There's a reference to a recent scientific poster that had been presented and a reference to data on concomitant use of benzos and opioid medications, right?
Yes, I see that.
And we see the indication data have shown that drug combinations of benzodiazepines and opioids contribute to at least 30% of opioid-related deaths, right?
I see that.
And then there is, if we flip forward to page 29, under the discussion section, we see the indication that the most common prescription drugs involved in overdose deaths in Oklahoma at that point in time are hydrocodone, oxycodone, and alprazolam, right?
I see that.
And then there are various action items that are set out at that point in time for the board, correct?
There is action item. Sorry, hold on. I got stuck because I was trying. Well, it doesn't matter. I knew that you all had prescribed the ingredients in hydrocodone and oxycodone, but I couldn't remember who made a lot. Xanax, that's what I was trying to remember. And you're asking me to look at the recommendations?
No, I'm asking you to look at what was reported as to be the most common prescription drugs involved in overdose deaths in Oklahoma as of that time.
Yes. I thought you already asked me that, and I already said yes.
All right. If I did, I apologize.
I may have remembered wrong, but I think you did.
All right. We also see within this packet for the board information about opioid analgesic trends in the 2013 to 2014 time period. And so I want you to move forward to that section, which is at page 61.
$61?
Yes. Thank you. And we see there a 6-year trend in utilization, right?
Did you say 6 years?
There's a chart, if we go to actually down below, the next one is coming. We see first a 6-year trend in utilization, and then below that, a top 10 products by claims for fiscal year 2013, correct?
I see both of those.
And what we see here are hydrocodone, APAP products at the top, right?
Mm-hmm.
And actually, I believe taking 1, 2, 3, 4, 5, 6, 7 of the top 10 spots at that time, correct?
I believe all of the top 10 spots are drugs that either are manufactured by Johnson & Johnson and Janssen, or the over 50% of the active ingredients were provided by Johnson & Johnson and Janssen, if that's what you're asking me.
Yeah, and I know you're eager to talk about API and thebaine production, but my question was simply whether 7 of the top 10 products are hydrocodone combination products.
Yes, 7 of those top 10 are hydrocodone products.
And that's consistent with what we see in the chart that's at the top of the page, which shows the prescribing trends between 2013 and 2014, which shows that short-acting claims far exceed the number of claims for long-acting opioid medications, correct?
Yes, this chart is scaled so that you can tell that, yes.
All right, so let's continue flipping through the utilization review. And I want to go to a chart that lists hydrocodone products. This is on page 68. And these are statistics related to immediate release opioids in the Medicaid population. You there?
Yes.
And the first category is hydrocodone short-acting products, right?
Correct.
And we see a total of 338,798 claims for 111,000 members, right? Subtotal?
Yes, I see that.
All right. Now, if you turn to page 70, we're still in the short-acting section, right?
Let me look. Hold on. It appears to be, yes, I think so.
And we see a reference there to tapentadol short-acting products about 2/3 of the way down the page, right?
Oh, where it says Nucynta?
Correct.
Yes.
And we see there the subtotal is 231 claims, right?
Yes.
Is that an oversupply?
So this would have been in 2014. I have no doubt that we had an oversupply at this point of opioids. When you're asking me, is this an oversupply of Nucynta? Is this if you look at what we had pre-96 for our opioids, according to the Piercefield study, and where we are in 2014 for opioids, absolutely we had an oversupply. I don't believe that Nucynta was measured prior to 96, but when you add together all the opioids for which Johnson & Johnson are involved in, hydrocodone, morphine, oxycodone, all the things on this chart that we've talked about, and Nucynta, absolutely there was an oversupply. If you're asking me, like you were earlier, about the specific claims for these individuals, I can't tell you which of these were an oversupply, but do I believe there was an oversupply? Yes.
So I take it from your testimony, it's not about Janssen's drugs, is it?
It's absolutely about Janssen's drugs and the drugs that Janssen provided the ingredients to make, and if I haven't made that clear, please let me be very clear about that.
So then tell me, Ms. White, is 231 claims for Nucynta an oversupply?
Then ask and answer. She had it very clear.
It wasn't answered, Your Honor.
It
Let's
was.
sustain the objection.
So let me ask you this. I take it from your answer then that in answering the question about whether there was an oversupply, you feel the necessity to pull in products from other manufacturers that may have used active pharmaceutical ingredients that were supplied by Noramco.
No, I do not think that is the correct characterization. I feel that Janssen and Johnson & Johnson oversupplied their own products that they manufactured. There was an oversupply of those. But I feel like you all have repeatedly through this trial tried to downplay your role in all of the other products that were opioid products for which you provided the ingredients. And I absolutely think that cannot go unnoticed. That is part of the story, but make no mistake, I do believe Johnson & Johnson and Janssen oversupplied their own products as well.
Just not these 231 claims for Nucynta, right? They're not part of the oversupply, are they?
I didn't say that. I said I cannot tell you an exact number, but I'm trying to say very clearly I believe that you oversupplied your products as well.
And so how, if you don't know what the right number is, how are we going to figure out what the right number of Nucynta prescriptions is so that we don't have this oversupply problem that you keep referring to?
That's been asked and answered.
That's an entirely different question.
Overruled.
I think that we can take the pre-96 levels of opioids in the Persefield study and the where we're at now, and there's a huge difference. And I think we should, I can't say we can, we should all agree we should go back to pre-96 levels, and that those are numbers we could use. Do I have those numbers memorized sitting here? I don't, and I'm sorry, I don't.
So every single prescription over the number of prescriptions for opioids that were written by Oklahoma doctors in 1996 is an oversupply.
I think that to abate the opioid crisis, we need to go back to the pre-96 levels. I think the oversupply trend clearly started happening when 96 and goes up and up and up. And I don't think I have to figure out if there is just one product over. I think the gap is, and the rise is so tremendous that it is obvious to everyone that we have a problem. And that if we return to pre-96 levels, we will have abated this crisis.
And Ms. White, you understand we will never return to pre-1996 levels of, for example, Nucynta, a product, a tapentadol product, which didn't exist in 1996, correct?
I understand that Nucynta did not exist in 96, but I believe that we can return to a pre-96 level of prescribing of opioids as we had for decades. Nucynta being one of those products, Duragesic being one of those products that have now gone generic, that Janssen and Johnson made, that they are continuing to profit from today. Products that Janssen and Johnson provided the ingredients for, that they are continuing to profit for today. I think we can take those as a category and call them opioids, just as you did when you did non-branded marketing around opioids, and say we can go back to pre-96 levels, and I think that is absolutely attainable.
So to get back to my question, because I don't think I got an answer, in your view, is every single prescription for an opioid, and I understand you want to lump them all together, every single prescription for an opioid over the total number that were prescribed in 1996 in Oklahoma is, in your opinion, an oversupply?
And I think I did answer that. I'm saying that there's the pre-96 level and there's the level today, and the gap is so huge, I don't think I have to try to calculate if we get to pre-96 plus 1 at this moment, if that's the right number. I cannot answer that question for you today, except to say that pre-96 levels, we know we had for decades. Those, we did not have the consequences that we have today, and that should be the goal of the abatement, and I believe that we can get there. So I don't think I have to worry about if 1's over, because I think we'll get to pre-96 levels. So I didn't contemplate 1 being over.
So is 1 over okay, or is that still an oversupply?
Ask and answer.
Sustained.
Let's talk about Nucynta ER. Turn to page 73, please.
Oops, I'm sorry.
You there?
Yes, I'm on page 73.
And you see the reference to tapentadol long-acting products.
I do.
And there's a reference to the various strengths of Nucynta ER, right?
Yes, I see that.
And you see there were a total of 74 claims, correct?
I see that.
Is that an oversupply?
I believe we had an oversupply of all opioid products, including Nucynta.
So you have to lump Nucynta in with all other opioids to offer the opinion that there was an oversupply of Nucynta?
I do not have to lump it in. I believe we had an oversupply of Nucynta. I believe that we had an oversupply of all products that Janssen and Johnson & Johnson manufactured themselves. If you're asking me on the specific claim, as you've asked me before, I can't tell you the specifics of these claims because I don't even have the information for these specific claims. But do I think we had an oversupply that you were part of? Yes.
So if I may approach, Your Honor?
You may.
So these 26 student care members, right?
Yes.
We don't know who they are, do we?
I don't know that sitting here.
We don't know what medical conditions they presented to their doctors with, do we?
We do not.
We don't know what factors their doctors considered in making the decision to prescribe the medicine for them, do we?
We don't have that here.
We don't know what therapies, what alternatives may have been tried to address whatever the medicine was prescribed for before the medicine was prescribed, do we?
We do not know that.
We don't know how those 26 Oklahomans, and when we're talking about student care members, we're talking about Oklahomans, right?
Correct.
We don't know how those 26 Oklahomans benefited from the Nucynta that they were prescribed by their doctors, do we?
When you say we don't know how they benefited, I would say we don't know if they benefited.
We don't know a thing about the outcome, do we?
Correct.
Now, another thing we don't know how many doctors wrote the prescriptions for those 26 patients, do we?
We don't know that from looking at this.
We don't know whether a single one of the doctors who wrote one of those 74 prescriptions was ever exposed to a communication from Janssen or from Johnson & Johnson, do we?
We don't know that for sure. Looking at this data, now someone may very well know that for sure.
Someone may, but sitting here today, we have no idea, do we?
No, that's why I'm saying I can't tell you for these individual claims. You are correct.
And we don't know what factors those doctors considered before deciding to write prescriptions for Nucynta, do we?
We don't know if, as you said earlier, if they were targeted by Janssen and Johnson & Johnson. We don't know if they weren't sitting here today. So no, we don't know for certain the factors looking for these specific claims.
And I assume, therefore, you would agree that we should not question the medical decision-making that was made by these doctors evaluating these Oklahoma patients.
I can't speak to the medical decisions made by these doctors, but I can absolutely say we should question the practices that Johnson & Johnson and Janssen participated in of trying to change doctors' minds, provide them with false information, and affect their prescribing to sell their product.
So no matter what the doctor made a decision on, for you, what's important is what might have been said by a sales representative, whether it had any impact on that particular doctor's prescribing activity or not, even if, that's even if the doctor was even visited by a Janssen sales representative, right?
I didn't say that.
What tier was Nucynta in? What formulary tier was Nucynta ER in at this time?
I don't remember if I've seen that here today. I don't know.
Well, the tier placement would have an impact on things that the doctor would have to try with the patient before the doctor would be able to obtain prior authorization from Medicaid to even use the drug, right?
I think that's true.
All right, Your Honor, this might be a good time to break for lunch, and I can get things organized. We can probably wrap up in 45 minutes after lunch.
Okay.
What time?
We'll start back at 1:30.
Thank you.
We'll go ahead and excuse you then. Thank you.
Thank you.